Hello, this is Heidi Meyers, immigration and fashion law attorney, and today we will talk about filing a federal court lawsuit if you are someone, a foreign national, an immigrant, who is affected by the USCIS pause on processing benefits for foreign nationals from their list of 39 countries. So, based on presidential proclamations 10-949 and 10-998, USCIS decided to hold and pause benefit applications in a series of memos. So the first memo was issued on December 2nd, 2025, and the most recent USCIS memo was January 1st, 2026. Now, these pauses, this hold in processing immigration benefits was based on two presidential proclamations that initiated travel bans. So it was based on presidential proclamations that banned entry into the United States for foreign nationals who were outside the United States at that time. Now, if you were born in or you're a citizen of one of those countries, and say you have a pending work permit or you have a pending application for adjustment or some other application that USCIS is failing to adjudicate, even though you've properly filed it, you can file in federal court and challenge the USCIS pause and failure to adjudicate your application. Now, you might think, should I join one of the large lawsuits? So there are a number of big lawsuits going. You might have heard of Clinic versus Rubio, and there's some other lawsuits with large numbers of people pending in the federal courts. So how do you decide whether you want to have your own individual lawsuit or you want to join one of those big lawsuits? For certain people, it might be a financial consideration. If, say, it's a large lawsuit and you don't have very much money and you can't afford to file your own lawsuit, and the cost is only $2,000 or $1,500 or something like that to join one of these group lawsuits, then that might be your only option. Or if your application is still within normal processing times, or if there's nothing particular or special about your situation, your best option might be to join one of the group lawsuits. However, if you're under a time pressure or there's something particular about you or your work, you may be much better off filing an individual APA, Administrative Procedure Act, and mandamus action to get your work permit adjudicated or your case adjudicated. So that will depend on your individual circumstances. For example, if your case is within normal processing times, but your work permit is going to expire, and you need your new work permit immediately in order to continue your employment, or if there's something particular about you. For example, in the USCIS memo, the recent one from January 1st, they listed particular exceptions, but the exceptions would have to be approved by USCIS headquarters or the directorate of the program. So, for example, if you're a scientist or a medical researcher whose research is in the provides a significant public benefit to the United States and it's in the national interest, or if you're an engineer with certain very special skills and you're working on a critical infrastructure project and something like that, or if law enforcement needs you for some particular reason. The USCIS, the most recent memo from January 1st, 2026, listed these as possible exceptions. Very limited exceptions, and the individual examiner could not make the exception for you. It would have to be approved by headquarters or the responsible person in charge of the particular program. So in that case, you might be better off filing an individual lawsuit. And also, like I said, if there's some time constraint, or if you have immediate family members who would suffer irreparable harm, for example, if you don't immediately get your work permit. For example, if your spouse has very serious health issues, and if you don't have your work authorization, you're going to lose your health insurance, and your U.S. citizen or permanent resident spouse has very serious health issues, that might be a reason too. So these are sort of general considerations, like why would you want to file an individual lawsuit rather than being part of a group. And then in general, with these large lawsuits, of course, they get a lot of media attention. And the large lawsuits are challenging the policy as a whole. So if you have your individual lawsuit, you can challenge the policy as applied to you in your particular situation, whereas these large lawsuits with large numbers of people, they're challenging the entire policy. For example, a large basis for this policy is USCIS, and the administration is alleging that if you are from a particular country and that country doesn't have sufficient vetting processes, or the identification documents are not reliable, you can challenge that. For example, if in your situation, perhaps you were born in one of these banned countries, but your parents took you from that country when you were a baby, and since you were a very small child, you grew up in some third country that does have wonderful vetting processes and is not a banned country, you can make that argument. Another example would be, suppose, aside from the list of countries, individuals with Palestinian Authority passports are also part of the pause, right? So the argument there is, suppose you're from the West Bank, you've got a Palestinian Authority passport, but you have some sort of permit from the Israeli government. So the argument would be, the Israeli government, the Ministry of Interior, has already sufficiently vetted you, and no one can argue that the Israeli government does not do a good job of vetting people. Now, in general, the strongest argument against the pause is that there is no legal basis for USCIS to fail to adjudicate immigration benefits for immigrants who are already within the United States. Now, the U.S. Supreme Court made this clear in Trump versus Hawaii. In that case, the Supreme Court made clear that the statute, 8 U.S.C. 1182F, only applies to foreign nationals who are outside the United States. And that once a foreign national is in the United States, 1182F no longer applies. Once a foreign national is in the United States, another provision of the INA applies, which is 1152. Let's see. Let me see here. Okay, 1152 A1. So that's 8 USC 1152 A1, which forbids discrimination in the issuance of an immigrant visa based on the person's race, sex, nationality, place of birth, or place of residence. So the Supreme Court has already determined this in Trump versus Hawaii. In another Supreme Court case, Zadvitas versus Davis, the Supreme Court again made the point that foreign nationals within the United States have due process rights. So foreign nationals outside the United States don't have any rights. They're not protected by the U.S. Constitution. But once a foreign national is within the United States, they are protected by the Due Process Clause. They are considered persons, regardless of whether they're legal or illegal, regardless of whether they are temporary or permanent immigrants. So the Supreme Court, in a couple of cases, has already made clear that the provision of law that USCIS is relying on, 1182F, does not apply to foreign nationals within the United States. And the Immigration and Nationality Act and the Administrative Procedures Act requires USCIS to adjudicate cases that are filed with it. I'm Heidi Meyers, Law Office of Heidi J. Meyers, 11 Broadway, New York, New York, 10004. My email is heidimeyerslaw@hmeyers.com. Our number is 212-791-4007 or 646-508-5225, and we can fight for you in federal court. Have a good day.